Welcome, everybody, to the New Voices panel for the American Society of International Law's annual meeting. I'm delighted that we are able to have this panel in the virtual setting, and a huge thank you to our three wonderful panelists for their papers and for their words today. I'm not going to spend a lot of time with pleasantries at the beginning, and we'll go right to the papers, but let me just very quickly introduce our three speakers in the order in which they'll speak. And what we'll do is we'll take sort of 20 minutes per paper. We have about an hour in total. We'll go paper by paper. So we're going to start with Desiree Leclerc, who is an assistant professor of international labor law at the Cornell School of Industrial Labor Relations, and was previously director of labor affairs at the Office of the U.S. Trade Representative, and before that, a legal officer at the International Labor Organization in Geneva. Following that, we'll have a paper by Dr. Jinan Bastaki, who is now assistant professor of international law at the UAE University. And finally, we'll have a paper by Ashley Uren, who is a senior legal officer with the Commonwealth of Australia's Office of International Law, and has just recently completed her LLM at the University of Georgetown, where the research for the paper was undertaken. So without further ado, let's turn to Desiree's paper.
Thank you very much, Jillian. And at the outset, I'd like to thank Azel for this opportunity to present today, especially under the circumstances. We appreciate everything that you all have done, and to Julian for moderating. Briefly, I'm speaking today on international organizations and unities, and in particular, the case of JAM, the IFC. The Roberts Court has done a lot of interesting things over the past couple of years that I don't think many of us would have predicted. Most recently, there was the Title VII case and LGBT rights. In 2019, the case that probably drew the most criticism and interest from the international crowd was JAM versus IFC, where the Roberts Court reversed over half a century of precedent to find that international organizations only enjoyed restricted immunities rather than absolute immunities. Before we get into that case, I just want to take a step back and explain why this was such a big deal. In the 1940s, when the UN was first created, the United States wooed the UN in order to get it to create its headquarters in Washington, D.C. A part of that package was the creation of the International Organizations and Unities Act, the IOIA, which stated that international organizations would enjoy the same immunities as that enjoyed by foreign sovereigns. That's important because at that time there was no statute governing the immunities of foreign sovereigns, but rather common law, which afforded foreign sovereigns absolute immunity from suit. A few years after the IOIA, however, the State Department wrote a really strongly worded memo advising that the immunities of foreign sovereigns needed to be restricted. So, in response to that, in 1952, Congress enacted the Foreign Sovereigns Immunity Act, the FSIA, giving foreign sovereigns only restricted immunities. And under the FSIA, in fact, there are 9 reasons that the immunities for foreign sovereigns can be restricted, one of which is when those foreign sovereigns are engaged in something called commercial acts. While the FSIA was restricting foreign sovereigns, however, circuits began to divide on whether or not the immunities of international organizations could likewise be restricted. And predominantly the DC Circuit Court, which overruled the majority of these cases because the majority of the international organizations in the United States are in DC, found that notwithstanding the FSIA, international organizations continued to enjoy absolute immunities. So eventually, this question made it to the Roberts Court. And in February 2019, the Roberts Court reversed all of the DC's precedent and held that just as the immunities of foreign sovereigns had evolved, so should the immunities of international organizations, thus opening the door and questions as to the scope and extent of this new restrictive theory of immunities. This case was a big deal and is a big deal, not only to international organizations experts, but also rights advocates. For years, including in the 1980s, attention has been attracted to the activities of not just international organizations, but in particular, that of international financial institutions, such as the World Bank or the IMF. Those institutions have also expanded over time and have undertaken various degrees of projects, such as those carried out by the World Bank or the International Financial Corporation, or through loan arrangements, such as those that we see with the IMF. Increasingly, allegations have been risen as to the impact on local populations that those international financial institution activities either implicate or undermine. And the fact that there has not been any real accountability when those organizations overstep their mandate and actually cause harm. Now, some might argue that that the developing countries in which these activities are being undertaken provide sufficient legal basis. However, what advocates, rights advocates, have learned is that often the legal structure is not there in these developing countries. So they've been looking elsewhere to find a platform for accountability. JAM was a welcome decision to them because these organizations are headquartered in the United States. They get a lot of their money from United States funding, and there's a nexus to the United States, according to advocates. JAM versus IFC has also drawn a lot of criticism, though, and well deserved. While the Supreme Court did something striking by reversing its precedent, I think we could all agree that it was a horrible decision. Instead of clearly establishing new guidelines or new limits for its restrictive theory of immunities, the Supreme Court cursorily said that the IOIA would follow the FSIA and provided no justification or clarifications. So, for example, whereas the FSIA provides 9 theories of restrictive immunities, the Supreme Court only mentioned one of them, which was the commercial acts exception. It didn't elaborate as to whether or not the additional 8 exceptions would apply. It also didn't elaborate as to whether or not the same legal standard for the commercial acts exception would apply under the IOIA context. And that's important because the legal standard currently applied under the FSIA is a mess with a number of split circuits and a lot of disagreement. So the hope, I think, would be that it would be a different legal standard, but that will be unfortunately fleshed out in years to come. Now, one of the things that I mentioned in my paper is that there's a spectrum of scholarship that follows the activities of international organizations, but 2 in particular. One is of functionalist scholars. Functionalist scholars believe strongly that international organizations should retain full immunities in order to carry out their functional duties. In other words, they're carrying out multilateral duties that member states cannot carry out themselves. To them, without officially declaring limits on restrictive immunity, JAM threatens the core operations of international organizations. On the other hand, there's constitutionalists. They view international organizations as constitutional creatures whose powers are limited by their internal instruments, such as their charters, as well as by external instruments, such as general international law and human rights norms. To them, without clear legal thresholds, JAM again could have harmful impact on the activities and, importantly, the autonomy of international organizations. So, in sum, while constitutionalists and functionalists usually differ when it comes to international organizations, they both agree that JAM is a bad decision. They fear that JAM could lead to excessive litigation, and they also fear that this litigation could lead to a fragmented legal order. Now, when I read these early reports after JAM, I realized I had a completely different view. I think it's one thing to say academically or theoretically that the opening of courthouse doors could lead to excessive litigation. And we're all thinking about like slip and fall cases or something where it's a tort in another country and then they sue in the United States because they want to get a lot of money. This is kind of the underlying theory or fear that kind of predicates many of these arguments. But for those of us who have been following the Alien Tort Claim Act cases or any other form of extraterritorial litigation, we should all be able to intuit by now that the Supreme Court and other federal courts are allergic to extraterritorial cases. It's not as easy as an aperture of courthouse doors to be able to lead to excessive litigation. And I don't think that we should expect that. On the other hand, change is needed. I feel like if you look at the number of reports right now, the lack of accountability, the lack of grievance mechanism, and the lack of voice for the many rights infringements that are happening around the world at the basis of international financial institution projects, you realize that there's a gap, and that gap somehow needs to be filled. So the question that I had and that my paper addresses is whether or not the aperture of the courthouse doors could be enough to incentivize reform in international organizations. In other words, whether or not the threat of litigation is perceived as real and real enough to incentivize greater internal accountability by international organizations, notwithstanding the allergy to extraterritorial cases that we all know exists. So, to prove this, I created a hypothetical case. It's a really weird article, but it was fun to write. I created a hypothetical case that was backed on and based on an actual fact circumstance. There was an outstanding case in Nigeria where workers were really, really harmed by an IFC project. And so they filed a complaint within the World Bank's internal mechanisms. And that case currently is stagnant, it's not going anywhere. So I took the facts of that case and I hypothesized what would happen if this group of workers gave up on the grievance system that's not working in the World Bank and instead brought the case to the United States. I realized very early on that if they rested it on the torts that they were incurring and that were harming them in their country, in Nigeria, they wouldn't stand a chance. This would suffer the same, result as our alien tort claim cases. But instead, I looked very closely at the contract in question, the contract that was established in the United States, the contract that benefited from funding by the United States, the contract that included express commitments to the United States government, so compliance to worker rights laws and norms, and an appropriate grievance mechanism. And I questioned what would happen if this hypothetical case was raised as a breach of contracts rather than as a tort claim. What would happen if the workers, as third party beneficiaries, under the federal rules of civil procedure, established that they had standing, established that they had an actionable claim, and established that they were intended beneficiaries? Where would that land us? And after walking through the contractual doctrines, I realized there might be types of contractual cases that might satisfy the many legal thresholds that the United States courts would apply. After jumping through those hoops, I then get to the residual standard that we still are faced with after JAM, which is that of the commercial acts exception. And I applied, unfortunately, the jurisprudence that we have under the FSIA, because until and unless a court says otherwise, we're stuck with it. And I realized that even with this legal standard, where you have to show that the activities or the harm was based upon conduct in the United States and that it was commercial in nature, I still believe strongly that there are cases that will satisfy these standards. And at the end of the day, all we need is one. We need one case that can make it through the doors, that can make it into the United States courts, that can establish to international organizations that there is a potential for accountability out there. Now, as I was writing this, I was continuing to grapple as to whether or not this was really going to be as obvious to international organizations as it was to me. And I was giving a presentation on this when I ran into an executive director of the World Bank, and I was kind of talking him through JAM. And he said, I don't even want to talk about JAM. JAM is all I hear about right now. Ever since that case came out, we're being called into meeting after meeting with the Joint Commission between the IMF and the World Bank to discuss what kind of new accountability measures we're going to have to undertake to avoid all this litigation that's coming our way. So I realized that, even at that one case hasn't made it yet, a process has been put in motion thanks to JAM, where organizations such as the IFC, the IMF, and the World Bank are going to really look hard. Now, there's an asterisk here because, for better or for worse, JAM's restrictive immunity will only apply to international organizations with a particular charter. Those charters have to already have waived their immunities. That's relevant because the World Bank and the IFC have that charter. On the other hand, the IMF has retained its full immunities. It is not subject to JAM's restrictive immunities, and nevertheless, it's part of this reform process, which I find very interesting. I'll conclude only by saying the following. This was a paper that I had written last year with very, very high hopes. Since then, obviously, things have changed. COVID happened. Will these reforms continue to take place, or have they been thoroughly eclipsed by much greater, graver, and more pressing dangers? I think that we're just going to have to follow this process very closely in the hopes that at the end of the day, international organizations will be able to continue their reform efforts. And that's all for me. Thank you.
Great. So what I'll do is I'll offer a few comments, and then we'll see if the other panelists have some comments. We might have time for you to respond. We might not, depending. I think we should probably move to the next session in about 5, 6 minutes. So when I read this paper, it's an excellent paper and a really interesting one on a case that is a bit of a Rorschach among international legal scholars. And to me, the main takeaways was, there's Desiree notes there's a lot of breathless commentary right after Jam comes out. And a lot of it is about a parade of horribles. Here are all the horrible things this case is going to do. There's all kinds of perverse incentives it's going to have. And Desiree does a really great job of deflating some of that, right? Deflating a lot of the speculation, not all of it necessarily, but the most important one, which is the parade of suits that are going to come through the door. So she suggests that suits are unlikely to come in droves, partly because of the sort of still very limited nature of restrictive immunity, and then all of the sort of hurdles, which what she calls the rules-based approach, where you actually look at the types of causes of action that we might have for these types of organizations, and they're not that easy to establish these kinds of suits in the first place, and then to get them through the door of exceptions to something that would look like the Foreign Sovereign Immunity Act. Hard to imagine a lot of that working. Then Desiree suggests that JAM might have some beneficial effects, which she's just been mentioning, which is creating incentives for internal reform to avoid these kinds of suits. Um, I think Desiree recognizes this, but we need to just put it right in the front and center that these 2 points are in a huge amount of tension with one another, right? Because on the one hand, you're saying, well, the suits aren't going to come, and on the other hand, you're saying, well, the threat of suits is going to make international organizations likely to shape up, and if the suits aren't going to come, now that's soluble, right? Uh, we're going to talk about Gordian knots later, but you can cut that Gordian knot as well, because the threat of suit is in the zone of uncertainty, and whether we as scholars can sit back and predict whether these suits will succeed under something that's analogous to the FSIA is one thing. When you're sitting in the boardroom of one of these international organizations thinking about your risk exposure, it's quite a different story. And especially when you don't intimately know the judges on the Supreme Court, it's not the same. So I think there's a soluble tension here, but one which we just need to think about front and center. Just a few further thoughts. So one, you know, on your final point about whether this really incentivizes the accountability mechanism, let's assume there's a threat of suit, right? There's a real concern about suits, but does this threat incentivize reform of accountability mechanisms? I'm convinced that it's possible theoretically, but I think more work would need to be done on the sort of back end of the paper, of a follow-on paper maybe on the back end, where you hedge, right? You don't make a causal claim. You don't say Jam is causing the IFC to reform, and that's good because who knows, right? Um, but it still feels a little bit close to a causal claim. I'm not saying as a methodological thing it's a problem, but to me, I need more about why those incentives are what move the needle for the IFC, and whether or not the IFC had things in the works before or not. Um, but but to me, it's not the IFC thing that's the more interesting part of that. What's really interesting to me is the one little paragraph you had at the end where you say the IMF also post Jam is adapting its accountability mechanism, and that's surprising because the IFC or the IMF doesn't seem to be subject to Jam, right? The IMF in its charter actually has absolute immunity, as you mentioned in the paper, and the restrictive immunity norm, according to the Roberts Accord, is a default rule, right? So it seems like the IMF shouldn't be worried about that, and yet they're reforming as well. So is there some other kind of cause jumping in? Accountability is in the air. Look what happened with UN peacekeepers and cholera. Maybe everyone is thinking about accountability anyway. One other point is that I think this is in a piece on just security by Cristina Dogirdas, but I'm not 100% sure. Um, I think it's her that she mentioned a really interesting additional perverse consequence that was possible, that a lot of the claim here in JAM relied upon data that was published by the IFC, right? And if that's the case, the concern is, well, if you want to avoid suits, you can improve your accountability mechanism, or you can just not publish the data on which you might get sued. So maybe it could have perverse anti-accountability effects as well that would probably be worth engaging with. But you would be more familiar with the specifics than I on that. I want to make one last point on functionalism and constitutionalism. I think your criticism of the scholars that you mention is fair, right? And your criticism of the particular functionalists, the particular constitutionalists, all fair. But I think you might be painting with too broad a brush about what all functionalists think or what all constitutionalists think, and therefore missing some of the power of what especially functionalism, can add to advancing your own argument, right? So with constitutionalists, right, I agree that it's kind of silly to say that restrictive immunity would overly interfere with the internal coherence of constitutional norms in an international organization. Yeah, okay, states are also constituted entities with constitutions, many of them, and they're not running to screaming bloody murder about restrictive immunity in the Foreign Sovereign Immunity Act. So I think it's a little bit silly to say, oh, suddenly international organizations aren't constitutional. Yes, maybe they have more constraints, but I don't think that's like a core constitutional issue. Um, Similarly with the functional point, right? I mean, there's this sort of circular reason in functionalism that Klobbers drags out, where the idea is, well, an organization should be able to do whatever its functions require of it. What are its functions? Sort of whatever it says it is, and therefore it should be able to do anything that it wants, right? This sort of vicious cycle, and that's all. I mean, he's right about that. You're right that that gets a little bit silly, but the sort of functional point doesn't have to really cash out that way. Functionalism can be really helpful where we're thinking about what the appropriate limits on restrictive immunity might ought to be. And one way to think about that is, look, the Supreme Court is saying it should be basically the same as states get under the FSIA. But what is the same, right? Think about what we mean by likeness in trade law, right? Likeness or any non-discrimination law, it doesn't mean identical. What it really means is equivalent. And when you're asking how we could translate the restrictive immunity regime applicable to a foreign sovereign to a international organization, maybe functionalism helps there to see, well, what are the kinds of things where we would want to create loopholes, and what are the kinds of places where loopholes are not appropriate here, right? So there, I think actually functionalism can help a lot, as long as we avoid the view of functionalism where it's self-defining, right? Whatever the organization claims are its functions, it gets to do those, or it gets those immunities. That has to be out the window. It can't be subjective. It has to be objective, and we have to be kind of hard nosed about it. But then at least the theoretical apparatus might be helpful. I am going on way too long. I'm looking at this clock now. So if either of the other panelists has a quick one, and then maybe we'll not have much time to respond, maybe 60 seconds.
I just had one quick comment. This was fascinating for me, not having, as an Australian lawyer, not having much experience with JAM, but I would be interested in hearing from you, if you've explored this, how it sits against decisions in other jurisdictions or approaches in other jurisdictions.
So Desiree, so I take
Okay.
about 60 seconds, 90
Sure.
seconds.
So that was a whole bunch. Thank you for those helpful comments, actually. And it's very interesting to see the way your mind is working about this, because I went through a lot of these same kind of loopholes, especially about the knot, right, and the tension. Because on the one hand, I wanted to dispel the concern that there was going to be excessive litigation, while on the other hand, proving that litigation is possible. And how do you kind of thread that needle? It wasn't easy. But at the end of the day, I rest firmly on the fact that I don't think it's either extreme. I think as long as we can get a minority of cases in, and I think it's going to be a very specific type of case, I think that will hopefully be enough to incentivize. But that leads me into your two other subpoints, which were somewhat related, in fact. The one that looks at, the causation of reform, and then also looking at, the ability of organizations to simply modify things to protect themselves. I think one of the elements I haven't discussed much, but which was in my paper, is the relationship between these organizations and the United States and its financing. And why that's important is because there's actually an entire process. The United States doesn't just write blank checks. And by the way, the United States is the number one funder of international. Trump hasn't pulled us out of everything. We're still the number one funder for a lot of things. Before providing that money, there's a back and forth between the United States and the federal agencies and the specific IFC, IMF, or World Bank project. By statutory criteria, one of the things that the Department of Labor screens these projects for, this is just an example, is for compliance with labor rights. And there's an equivalent for human rights and environmental rights and what have you. So F organizations take a defensive posturing. F, the IMF excludes itself from conversations. F, the IFC simply decides to withhold data, and that is ever proven. What are the implications that will have on the check writing procedure of the United States government? These are the type of things that executive directors are thinking about. They know the game. better than we do. Even I've seen it, but I've never been, I've never sat at that table. They're very affluent in these discussions, and they realize a lot of this is about perspective and a lot of this is about legitimacy. And if the executive directors in the United States and other countries, this isn't just the United States, I'm sure Australia has its own procedures, what have you, before these governments decide to fund, they make sure that whatever it is about that project rests okay with them. So I think that it goes to your question, Julian, as to why the IMF would be. Also, as far as what the IFC can do, there's a number of things they can do. They can withhold data, but critically, remember, this is a default rule, right? They could change their charter. They could create new clauses in their contracts, particularly making sure that third parties can't sue them. The important thing to realize, though, is they still have to get the check written from governments. So if the United States as a member is engaged in a process to, make full immunities under charter, do you think that's going to be okay with it? Or Australia or any of these other countries that want accountability? So in any event, it's a more complicated
Okay.
process.
Okay, great. Thank you. And sorry to cut it off early. We could talk for a full hour on this and on each one of the papers, but I think we need to move on to Janan's, and I will move quicker in the next sets of comments. Sorry, everyone.
No problem. Okay. Thank you so much, Julian. And thank you, Desiree, for your paper. That was very interesting for me. And thank you to Aisla also for organizing this virtual meeting for us. So hopefully I'll stick to 10 minutes. And so the central question of my paper, it's still a working paper, is does citizenship impact the right of return of a particular group of people, those who have been displaced from their homes, and became refugees or sometimes maybe internally displaced people, and then also acquired citizenship outside of the territory of their own home. So there are a lot of arguments that obviously we can talk about obviously the issue of nationality, but the right of return is to the country of your nationality. But in cases where groups of people or even individuals have been displaced from their homes, and have been denied return, especially in the context of, for example, an ethnic conflict or when a new state is created. Um, does this new citizenship impact or even erode the right of return of that displaced person to return to their former home? And obviously, like this has kind of like real life implications, especially because we look at, for example, the controversies surrounding, for example, Palestine, Israel, or if we even look at, for example, Cyprus and the Turkish Republic of Northern Cyprus. Obviously, it hasn't been recognized, but still there are some important cases that the European Court of Human Rights has ruled upon, and kind of showing that actually citizenship could erode the right of return of displaced people to their former homes. In essence, almost rewarding a state for denying or being persistent in denying the refugees their right to return. And at the same time, also penalizing those refugees for wanting a stable life and acquiring citizenship where they are. And so I wanted to look at this from two different obviously bases. We have the individual right of return. We can look at that in terms of international nationality laws as well as human rights law, and then even the collective right of return under the self-determination paradigm. So when we look at the individual right of return, especially if we look at the International Covenant on Civil and Political Rights, we know that in Article 12, every person has the right to leave and to return to their own country. And the Human Rights Committee interpreted his own country as including those people who are denationalized, as including those people who were denied even denied citizenship in a place where they have ties. And the Human Rights Committee also specifically mentioned the right to return to one's home where they have special ties. They didn't really go into what special ties mean, but they mentioned this point. So obviously, the right of return to the country of your nationality, formal nationality, is not controversial. But when we look at the content of special ties, and we know that the Human Rights Committee specifically mentioned those who are denationalized. But if we look at it in the context of a prolonged conflict, if we look at it in the context of um, the rights of the secondary occupants, for example. And then we look at those people who have acquired this new citizenship and where their special ties are. If they spent decades in that country of of the citizenship of or of their nationality, their special ties end up being in that country of their formal nationality, despite the fact that perhaps over all of these years they have wanted to return. And perhaps most concerning in this case is the European Court of Human Rights decision in the Demopolis case. So prior to the Demopolis case, the European Court of Human Rights had consistently ruled for applicants who wanted to return to their homes. It's not specifically the right of return, but the right to access to their homes. But in the Demopolis case, the court went on and started talking about what does access to your home mean, and is your home really your home if you spent decades away from your home, and that a home doesn't mean an emotional tie or a family tie, but it has to be something that is more concrete. And this is in the context of the European Court of Human Rights recognizing that the Turkish Republic of Northern Cyprus is not a state; it's under Turkish occupation, and these people are being denied. Or have been denied all those years their right to come back. And in a sense, it's almost rewarding the Turkish occupation for its persistence in denying people the right to return home. However, I think my contention in terms of the individual rights is that we have to look at, an individual's right to restitution, and part of restitution is also the right to return to your former home. Yes, there are complications and there are logistics. What if your former home is now occupied by somebody else? And we also saw these cases in Bosnia and other places where there are ethnic conflicts. However, I think it cannot override a person's right to return to that home, especially within the context of a legal wrong. And we can also say that the right of return can be to more than one place. Maybe 50 years ago or 100 years ago, this would have been unthinkable because your nationality is just one nationality, and you can be, denationalized if it's found out that you have two. But nowadays, many people have, dual or even multiple nationalities, and they have rights in each jurisdiction. So it's not um, a stretch to say that a person can enjoy the right to return to more than one territory. But there is still obviously the issues of that we need to contend with, which is the special ties, and does it apply to the next generation and the generation after that if it's been generations that have been denied their right to return home. What then happens to that right? And so these are the questions that kind of grappling with in this case. And then we turn to also the collective right to return. So here I was looking at the self-determination paradigm, and this obviously doesn't apply to all cases, but it obviously applies to some cases where it's been recognized that these people have the right to return. And the ICJ has ruled in many cases concerning self-determination. We have Namibia case, Western Sahara case, as well as the East Timor case, which they didn't really rule on, but where they reaffirmed the people's right to self-determination, and this included people who were displaced. In the East Timor case, it's most interesting because the East Timorese who were displaced at the time, they had Portuguese citizenship, and that doesn't preclude them from being part of the collective that should be allowed or that has the right of return in order to be able to determine their political future in that territory. So in a sense, the right to self-determination, it's stronger if it's a group of people, if it's a group of displaced persons that have been denied the right to their territory. But at the same time, that is also eroded, maybe not so much by citizenship, but by political negotiations that can limit the rights of that collective. And in a sense, the people who do have citizenship, who have acquired citizenship elsewhere, their they are less of a priority. So even within the context of, for example, Israel Palestine or Palestine Israel, the people who are thought of as desperately having the right of return are those who are stateless in Lebanon, for example, and not those who have citizenship in Jordan or have migrated to the United States or to anywhere else. And this is kind of the issue that my paper is seeking to kind of interrogate, and that in some senses the people retain the right of return under, we can say, self-determination and human rights law, but within those very bodies of law there is a kind of erosion of their rights due to the acquisition of citizenship. I'm going to stop here because I think I've went over 10 minutes.
Great. So I think I'm glad that you didn't stop 10 seconds earlier, because your point about erosion is helpful. So Janan, so this is a paper at a significantly earlier stage than Desiree's. So the sort of tenor of my comments will be more different and focused a little bit about where to take the paper, which I think is fascinating. So personally, I'm less familiar with the area. But to me, it's striking the way that you bring these different areas of law together to get at the point, right? So the actual legal question that you have is a relatively discrete and narrow one, although quite an important one. Is there an international legal right of return where a displaced person has been granted citizenship elsewhere, right? That's basically the question. And it's sort of one of these issues where, it's not like some rule somewhere that just addresses this. And what I really appreciate about the paper is that you don't just come at this and say, well, why are all the sort of list of individual rights that you might have, human rights and nationality? You do go through, and that's great. But you also ask about collective rights, which is a completely different type of regime for dealing with this. And I think that has the potential to be very fruitful. And I would encourage you to push on that division a little bit more in a couple of ways. So the paper thus far sort of goes through the lay of the land in each of these little legal regimes, which is something the paper will have to do. And the question is not just whether there is a right of return, but it's really from whence it comes and what is the content of that right under these different regimes, right? It's not one right necessarily. So that's a great descriptive sort of fodder, but I didn't really see a descriptive thesis until what you just said at the very end of your spiel, which is that the descriptive thesis is there's little sort of fragments of a right in each of these areas, but that right has been eroded across each of these areas. Right? That's a pretty powerful descriptive claim. And I think you might want to just put that right in the very front, right? Like my first descriptive claim is that there is some sort of right that one could cobble together from these different regimes, but it's one that's being eroded in various ways, and not necessarily even intentionally. Right? These are all sort of the cases that you talk about are about all kinds of things, but taken together through the lens that you're looking at, there's some sort of erosion. Right? So that's the first point. But I think I would encourage you to also try to push into normative directions a little bit further, right? And it seems pretty clear reading the paper that you think that this right should not be eroded and should be expanded. And it's worth sort of putting your own voice in a little bit more. It's not just a matter of saying what is the law on this, and working for the International Law Commission or something. I think having the argument would be helpful. But even if you don't want to do that very strongly, what I'd really encourage you to do is to think about the tensions and trade-offs of getting at this sort of right across these two very different kinds of regimes, right? About through the individual route and through the collective rights route. Right. So obviously nationality, the law of nationality, the law of international human rights, those are quite different themselves. But the sort of umbrella one is the individual rights approach. Umbrella two is the collective rights approach. When you just read the paper kind of quickly, and it's an early stage, obviously, it's sort of not immediately clear why you have these two things. I think eventually it becomes clear that it's a descriptive point to try to show all the different places where these rights might come from. But I think you could push it further to say, what is the advantage to doing this through individual rights versus what is the advantage to doing this through collective rights? Right? There are real trade-offs there. If you do it through individual rights, you're thinking more about things like in restitution. You're thinking more about claims of individuals who want to get their stuff back, to get their home back, to have their own dignity be recognized, to have their own history sort of returned to them. But the pressures and functions of a collective rights regime are completely different. Right? It's not necessarily about that kind of restitution. And the claims of individuals might be sacrificed to the collectivity, right? The collective rights is actually quite, it's communitarian in nature. It's not liberal, right? And that's fine to have both, but they exist in tension. This is going back to Bruno Sima's from bilateral to community interest, right? There's two very different kinds of visions of international law, and it's not always clear that the communitarian one is, you know, normatively preferable in every way. Of course, we need some right of self-determination out there, but at a certain point, once you start thinking about individual claims being sacrificed to the greater whole, that could be worth taking into consideration. So I think if you focus the article not just on finding the fragments of the right in all of these different regimes, but also thinking about what the trade-offs of grounding a hard right to return in each of these different types of regime might be, it could be really, really fruitful in and then also the kind of thing for a research agenda going forward. I'm sure there's really quite a bit more one could do with the tension between the sort of communitarian rights of self-determination and the individually oriented rights of human rights and maybe the law of nationality. But yeah, it's very, very interesting to me. Um, I don't want to short shrift Ashley, so I think I'm going to limit responses. If you want to just take 45 seconds or a minute, and then we'll go to Ashley. Um, Sorry for the timer problems.
No, no, no worries. So thank you so much. So this is actually like very, very useful for me. And yeah, it's just at the starting stage of my paper. So definitely I do kind of want to look at the tension between the both, because as you said, like sometimes you do sacrifice, and especially if we look at least in the, I guess, the most obvious or even contentious case of, for example, Palestine, Israel, there is a talk of sacrificing the individual rights for the collective. So the collective is Palestinian self-determination in the West Bank and Gaza, and for those who are stateless and they can return to those areas. So that I think the tension is actually the clearest example. So definitely, I've written down your points, and I'm definitely going to be including them as I develop the paper further.
Great, thank you. All right, Ashley. Sorry for the time.
No problem at all. Hello, everybody, and I'd like to echo the other participants' thanks to Aisel and Julian for this discussion today. I wish we were able to meet in person, but given current events, I'm still very pleased that we're able to meet virtually, and I'm able to share with you some of my research on investor-state dispute settlement reform. I've undertaken this research, as Julian said, as part of an LLM at Georgetown University, and in that respect, I will make the usual disclaimer that this research and the views expressed represent my personal views and do not represent the views or the position of the Australian government. I also wanted to thank the viewers, whenever and wherever you're tuning in from, for taking the time to view our discussion today. So as mentioned, my research is focused on the current multilateral efforts to reform investor-state dispute settlement that are taking place in the UN Commission on International Trade Law's Working Group 3. And if I could start with some broad comments that really pick up the theme of this conference and the promise of international law, my observation of Central Working Group 3 and its process is that it's starting to involve some highly creative proposals to implement a range of ISDS reforms with an emphasis on flexibility over consensus. So while the topic of my research is quite technical and specific, I think the approach to flexible multilateral treaty making that we're seeing in UNCITRAL's Working Group 3 will have broader opportunities as well as challenges and lessons for international law, and perhaps even more so in the context of the unprecedented policy challenges the world is currently facing. So in the interest of time, I will assume some knowledge about the ISDS mechanism and the Working Group 3 reform process. Some people, including the chair of this panel, know that process very well, but for those who do not, I will briefly introduce. So UNCITRAL Working Group 3 is in the final stage of a three-stage mandate for possible reform of ISDS. And the mandate in many ways represents the culmination of growing criticisms and concerns with ISDS over the past 20 years, in which time the number of disputes has grown from around 30 to over 1,000. And pursuant to the first step of the UNCITRAL mandate, states and observer organisations participating in Working Group 3 identified concerns that they held with ISDS. And Working Group 3 has categorised those concerns into three key areas, including the consistency, coherence and correctness of arbitral awards, and also the cost and duration of arbitral proceedings. So the second stage of the mandate, which was concluded in April of last year, was that the working group decided that addressing those concerns was desirable. So now we're in the third stage of the mandate, which is to develop relevant reform solutions. And now when we're speaking about reform in this context, we're talking about reform to the ISDS procedures as they exist in thousands of underlying bilateral and regional investment treaties. So instead of taking a bilateral or regional approach to reforming those treaties, there's a general agreement in UNTITLed Working Group 3 that there are benefits to undertaking this reform process multilaterally, both from an efficiency point of view, but also from an attempt to avoid fragmentation. And to that end, states in Working Group 3 seem to be in agreement that any potential reform solution will need to address the procedures for disputes arising under existing or first generation investment treaties, as well as disputes arising under future agreements. However, there's not consensus in Working Group 3 about what those solutions should be. Many may be familiar with the proposal to establish a new permanent mechanism that would replace ad hoc arbitration in resolving investment disputes. However, some states have expressed a desire to retain ISDS, potentially with some procedural reforms that would reflect modern investment treaty practice, potentially with or without an appellate mechanism, which does not exist in the current system. So in early discussions in Working Group 3, those prospective reform solutions were discussed in very binary terms. But an interesting development that has occurred since the last meeting in October last year is an idea of creating a single, flexible, multilateral treaty, framework, or institution that would allow multiple reform solutions to be developed and then implemented by states on an optional basis. Several states and academics have advanced models of different flexible multilateral treaties. And while they have their differences, most are based on variations of the same concept, and that's that ostensibly competing ISDS reform solutions can move forward for inclusion in a single instrument or institution, and that states would sign up to the architecture, they would opt into individual reforms, and where the states have opted into the same reform, that reform or choice of procedure would apply to an existing bilateral treaty as between them. So including these optional parts, provisions, or protocols in such a multilateral treaty would probably involve a choice of procedure, and that would be at a minimum between a court, traditional or reformed ISDS, and or an appeals mechanism. So the appeal of a model like this is that it promises to improve ISDS and address concerns with ISDS while optimizing flexibility for states to choose or not choose, or choose a combination of different reform options. And this allows the discussions to progress even though there's not currently consensus for any one solution. So you might be thinking that this all sounds like quite radical. In many ways, it's a departure from how we might generally understand treaty making, where states are agreeing to the whole package with limited reservations. Yet there are examples of existing treaties in international law that use varying degrees of flexibility. And in Working Group 3 discussions, states and scholars have drawn on these treaties for inspiration. So in my paper, I go into these examples in some detail, which I don't have time to do today, but I'll mention a couple of examples that have been drawn on. First is the OECD, Multilateral Convention to Implement Tax Treaty-Related Measures. The full name is on the screen, it's a mouthful. And essentially, the operation of this treaty sees parties applying individual provisions or optional alternatives to meet minimum standards. And like the illustration I showed before, where there are matches between optional provisions states choose to apply, they must then be read alongside the two states' existing bilateral double taxation treaty. Another example is Article 287 of UNCLOS, which has a choice of procedure. And the way that operates is two disputing states must nominate their preferred procedure. Where there is a match, that will apply. Where there is not a match, the procedure defaults to arbitration. And in their research, Schill and Vidigal have, as Julian alluded to, called this a solution for cutting the Gordian knot. And they've also referred to it as dispute settlement a la carte. And in my view, an argument that I make in the paper, while these are useful examples, ISDS reform will very likely have a higher level of ambition and flexibility. And because it will govern procedures in litigation in a triangular relationship with investors, if not done correctly, it has the potential for unintended implications that might actually exacerbate the problems with ISDS that states are seeking to address through their reform efforts. And that doesn't mean that the project should not proceed, but just that states should be careful in ensuring that the remedy is not inadvertently worse than the problem it intends to resolve. And to borrow from Shilin Bidigal's analogy of dispute settlement a la carte, states are at the same restaurant, they're choosing different reform options from the menu, but how do they know that they're actually getting what they ordered? So in my research, I'm deliberately taking a very critical perspective. I'm trying to forecast some hypothetical procedural scenarios. I can't believe, Desiree, you did that as well. I thought I was the only one taking such a strange approach. But I have taken the same approach and drawn on facts of actual ISDS disputes that have given rise to concerns with ISDS. And in my time available, I just wanted to highlight one example about how the operation of a multilateral treaty might relate to states' identified concerns with ISDS. So in this example, states A and B are party to a multilateral treaty, and that treaty has a choice of procedure clause. Both states have nominated a potential multilateral investment court permanent mechanism as their preferred procedure. State C is also a party to the multilateral treaty, but has nominated arbitration with limited procedural reforms. So all states have bilateral investment treaties as between them. State C has an investment treaty with State B. And assuming in this scenario that the procedural clause actually does have a default and designates arbitration as the default where there is no match in the nominated procedures between states. So we see here by seeing the example through to its conclusion that as between states A and B for their treaty, the MIC will replace ISDS. But as for B and C, because there is no match, the default, which is arbitration, will continue to apply. So in this hypothetical, we also have an investor from state A who makes the decision to restructure to state C. We won't mention the reasons why they restructure, but in this scenario, they then bring an investment dispute against state B. Now they are located in state C. So in this scenario, state B makes an objection and submits that it shouldn't be determined through arbitration and that the proper forum would actually be the MIC. So what questions would a tribunal have to determine? Well, the tribunal would need to determine what the correct forum is, and to determine that applicable procedure, they would be reading multiple levels of treaties and procedural rules together. The second point to note as well is that a tribunal might hear this objection even if they ultimately determine that the appropriate forum is the multilateral investment court. And this, of course, will have costs and duration implications for both disputing parties. So you can imagine that in this scenario, different dispute bodies might arrive at different interpretations through reading all these instruments together, through applying the Vienna Convention on the Law of Treaties interpretive framework, and understanding these different interactions in different ways. So that, of course, will have implications for the coherence and consistency of decisions, which is one of the concerns that states have also been minded with these processes. So in conclusion, it's important to keep in mind that a multilateral treaty will be applied in practice by adjudicators of ad hoc tribunals or a multilateral investment court, and will establish the procedures for hundreds of investment disputes. We can also imagine contentious interpretive issues about the applicable procedure arising in future ISDS litigation with implications for cost, durations, consistency and coherence of decisions. Now, participants in Working Group 3 have already begun to notice this tension between flexibility and coherence because a multilateral treaty has potential for many asymmetrical nominations and significant rule complexity. So my suggestion in my paper is that hypotheticals such as the one that I shared today will help states to understand with more specificity the potential for interpretive controversies and ambiguities in the applicable procedure. and start to mitigate against those risks. So I suggest that the next stage of this research and for participants in Working Group 3 is to begin to draw on technical analyses to inform those discussions when looking at the proposed models before them, and to try to reduce rule complexity while retaining flexibility and also achieving the objectives that have driven states to consider reform in the first place. Thank you.
Well, Ashley, I apologize for the world's loudest phone. This is not my phone. I don't know why this phone is so loud. Everyone, I'm sorry about this horrible phone. It's unplugged and destroyed now. So Ashley, it's a fascinating paper, and in the moments that we have before everyone's children lose their minds and start taking over this Zoom call, let me just give you a few thoughts. So I think it's really important. There's a lot of, as Ashley identifies, there's a sort of lot of excitement about the flexible form as the way to preserve consent in the international lawmaking process, where there's so many treaties that need so many reforms, so many concerns about these treaties, and it's so hard to imagine a multilateral moment in, especially the context that we find ourselves today, to resolve all of this stuff. It's not just one single multilateral instrument. It's a multilateral instrument to sort of end thousands of bilateral ones. It's just hard to imagine it. And there's this excitement about the flexible form as a way to cut through the Gordian knot. I got to stop with this knot. But Ashley, I think you're really on the right track in asking whether there are going to be some perverse consequences from all of this excitement, even if ultimately the flexible form is a fait accompli. The question is to think about how to design it in a way that avoids some pitfalls that we might miss in all of the excitement. And I think you spot some of them really in a very useful way. And I would just maybe even suggest drawing out your sort of implicit framing a little bit more, which to you, it seems like obviously there's a tension with consent and too much rigidity, but there's also a tension with flexibility and consent, right? It's sort of like consent has problems in both places, and what with all of the excitement about flexibility in the lawmaking process, in the process of deciding exactly what commitments we want to adopt, we might find ourselves stuck with things that we didn't order, as you say, down the line, right? So ex ante flexibility seems better for consent, but maybe the complexity will create problems down the line. Whereas ex ante rigidity might be problematic insofar as states might not want to sign on to these treaties. If like a full on multilateral investment treaty might be more than states can stomach. But then you're sort of going to have all of the consent problems that we currently have from the investment treaty regime. And so I wonder if there are some ways to bring that out. And your analysis of the Vienna Convention, I think, is a really fruitful place to build further to make some of these points, the interpretive rules of the Vienna Convention. And maybe a way to do that is to add a little bit of comparison. It's so hard to do any analysis of treaty interpretation in investment treaty jurisprudence because it's so incoherent, right? You have all of these tribunals constituted on a one-off basis. You can't really figure out what the common approach to interpretation is there. But here we are talking about creating a multilateral institution with a court, maybe an internal dispute resolution mechanism, maybe just an interpretive mechanism for deciding what the multilateral part of the convention means, even if states don't sign on to all of the sort of MIC or all of that. And that body, if you are creating that kind of institution, is going to make decisions about treaty interpretation in a much more coherent way. And so it's worth drawing on the experience of other international courts there to see what they do, especially like the European Court of Human Rights, the ICJ, looking at how they apply canons of interpretation, like, for example, 31.3c, the systemic integration rule. And what you start to see is they do it in very problematic and expansive ways, problematic from the point of view of consent, right? So that analysis might sort of help kind of dive back and forth between the sort of ex ante and ex post consent problems, right? So I think maybe if you're considering pushing this into a sort of law review article or a peer review article direction, it might be worth sort of de-emphasizing a little bit of all of the different models that are out there, since, as you say, at the end of the day, they're kind of the same, or at least they create the same problems. And then thinking through really, maybe from both the ex ante and the ex post perspective, what's the tension between rigidity, flexibility, and consent, because it's not like a one-off trade-off. And that's the most important point of the paper, that flexibility does not preserve consent more than rigidity. It just depends on your optic and your time slice. And I think that would be a really interesting and useful thing to bring to the conversation before this train leaves the station, but maybe it already has. I know we have these sort of shadow minutes, so if you want to just take a moment to respond, or if anyone else wants to jump in.
I just wanted to thank you for your comments, and I think I'm treating it in the same way as you are. That it appears that people are really optimistic about this, and I think it has a lot of opportunities. But I will look to push my paper in the direction that you've suggested, and hopefully, maybe we can continue these discussions in another format.
Well, with that, and sorry for the short shrift on the questions to everybody, I've been commanded to wrap up and I obey. So thank you so much to our panelists. It's been a wonderful conversation. And I really look forward to continuing the conversation offline. And I hope others will reach out to our panelists about their papers as well after having viewed this asynchronously. Thanks, everyone.
Thank you.
Thank you so much.